Hi everyone, I'm attorney Poonam Minhas. I practice U.S. immigration law all over the United States. I'm back again with another N-336 matter. This time the scenario is a little different, so stay tuned and keep watching. Okay, so before I jump into this topic, I do have a favor to ask. I know a lot of you have been watching the videos, but no one's subscribing. So if you want this information to make its way to somebody who really needs it, please hit that subscribe button, hit the bell icon so you could stay informed about any updates I post. Like the video if you like the content, drop a comment, let us know where you're watching from, and also please share this with friends and family because you never know who this might help. So I'll give you a moment to do that before I jump into the topic. So someone came to us about their N-400 being denied, and this person filed their case pro se. USCIS alleged, you have not established continuous residence in the United States, you failed to maintain physical presence in the United States, and you have these trips that were taken where you were abroad for over 6 months, and now we think you abandoned your residency, that your intention was really not to establish your life in the United States as a green card holder, so why should we give you citizenship? Denied. So that's pretty much what the allegations were. I mean, there were a couple of more, but I just wanted to give you a gist of what that denial looked like. So we worked with this client and we really found out what the issue was. We found out the reasoning of the frequent trips abroad, why some of them were lengthy, and what was the reason behind it. Of course, I do want to mention that when you file for citizenship, you want to make sure that you have all the evidence ready in order to show USCIS if something pops up about maybe a lengthy stay abroad, or there's something that is an issue with like your good moral character. So you have to look at the requirements and see if you meet them. And if you do, great, go ahead and file for citizenship. But if you don't, just be aware that maybe USCIS might issue you a request for evidence, also known as a RFE, or a NOID, notice of intent to deny your case, asking for additional documentation. Now, some people I also know end up just getting a straight denial without being given an opportunity to really address the elephant in the room. What's the actual issue deterring this officer from giving you that approval? So that does happen. And of course, I would always recommend having your case checked out, evaluated by an experienced immigration attorney to really see what the red flags could be. So in this case, we found out, like I said, from the client, what was the reason of the travel. So I do want to just mention it was medical. And the treatment abroad was a lot more cheaper than getting it done in the United States. So we developed this case. We also noticed that the calculation for the physical presence was off indeed. So that is an error that we detected. And we presented this very strong case for the N-336. And lo and behold, we were able to get a hearing within 4 weeks, which is excellent. Usually cases do take a little longer. But if it is a very strong N-336 matter, you could end up seeing a hearing or a decision or some type of action as soon as 4 weeks. I've seen some as early as 2 weeks. So it's totally possible. Some people don't end up waiting the full 180 days. And depending on the complexity of the case, it could be longer, as I've said in my previous videos. So we were able to successfully prove that the calculations were off, and we were able to tackle the issue of, why weren't you able to establish physical presence in the United States? What about the continuous residence? This client did have a lot of evidence to prove that, they maintained ties to the United States while they were getting their treatment abroad for their medical issues. So that's really, really important, and how you present it becomes very important as well. So there are a couple of things I would like to mention so it's a little easier to follow. In this scenario that I mentioned earlier, the reason why an N-336 was the better option versus refiling for citizenship was because we were able to tackle the allegations against the client and to also prove to USCIS, hey, we can overcome the grounds of citizenship, of the denial, and try to get it overturned because of these reasons. And here's the evidence to prove it and to back it up. And lo and behold, it was a successful outcome. And in that scenario, the client didn't have to wait another, 4 years and 1 day or whatever the requirement was to wait and refile later to establish the presence and the residence, the continuous residence. So, that saved a lot more time by doing the N-336 hearing versus refiling the N-400 and waiting it out another 4 years or so. So sometimes it's best if you're really confused, you're not sure what to do, sit with an experienced immigration attorney, go over your case, provide details, explain your situation, and really see if there's a way to appeal that decision versus having to wait and filing later on, because the issue is not going to go away, right? The issue is still going to be there, and you want to make sure you handle it in the best way possible. Now, in this case, there was no fraud, right? There was no criminal issue. It was a completely different scenario. And there were extenuating circumstances. Obviously, the person had to travel for medical reasons, right? And it was absolutely necessary. And when it was medically feasible, then the person was able to come back to the United States. So, USCIS needs proof. And how do you prove it? That's where the magic happens. That's where the creativity comes out. And that's how you work with your client closely to develop a case and see how it goes. Now, N-336s are not guaranteed, of course, but if you have a strong case and you have an understanding officer, and remember, it's a brand new officer that gets this matter to really look at everything and analyze the case de novo to see, okay, you know what? Does this applicant get another shot? And can we reverse the original decision and allow them to go for their oath? And in this case, that's what happened. So we were really, really happy that it turned out to be successful. And we're really happy for our client who's about to become a citizen. So very, very happy for that. Now, I wanted to end today's video by just giving a few pointers and mentioning a few important things, which a lot of people probably don't consider when they're filing for citizenship. And I've said this numerous times. The citizenship application that goes to USCIS, it's not just a form. Okay, there's important questions on there. You need to know your immigration background, your history before applying. So if you have a criminal matter, if you have a conviction within a statutory period, or if you have good moral character issues, or you have probation that's still pending, or if you have a situation where maybe perhaps the green card was obtained through some type of fraud or misrepresentation, or there is some type of fraud or misrepresentation that could come up, or there could be several different things or scenarios where it would be extremely detrimental for you to fill out an application for citizenship, file it, and then end up dealing with a bigger issue. So stop right there if you have, some type of issues in your case, and contact an experienced immigration attorney to really go over it. Now, some of you, got approved at the citizenship interview and you're waiting for your oath ceremony, right? And this is important because I've come across recent consultations about this, and I thought it was wise to share this with you today because it was very alarming to see, is that the time frame from the time that you get your approval at the citizenship interview to the time that you are about to get scheduled for the oath and you're finally going to your oath ceremony. Be careful from that time frame. That time frame is crucial, is important, and there could be circumstances at that stage which could cost you and negatively impact your citizenship case. It's possible. I've come across individuals who've gotten a charge against them during that period where they're waiting for their oath, or they got a speeding ticket, they have a new ticket that's open, or something else happens. So at that stage too, you have to be careful because now if you have a situation that is going to negatively impact your citizenship, that's going to cost you your whole case and you might have to start from scratch. Or, you might just get a denial at that point. It's just not worth it. You have to be careful. Everything is crucial, especially when you're going in for oath. And you don't want to lie either when you're going in for your oath. There are questions they do ask you, and there's a reason why USCIS asks you these questions, is because they want to see, has anything changed from the time that you were approved at your N-400 interview up until the oath. And if you find yourself in a really bad situation, pick up the phone, speak to an experienced immigration attorney, set up that consultation to see what your options are and what's the best thing for you to do. Okay, everyone, I hope today's topic was helpful. I really, really encourage you to hit that subscribe button if you haven't already. Hit the bell icon to stay updated on anything I post on U.S. immigration law. Hit that like button if you enjoyed today's topic. Please use the comment section below if you need to write in something that's general, or if you want to talk about where you're watching from, that would be great. And do share this with your friends and family because you never know who this might help. So I will be back soon as I find out anything new about immigration or there's a case I would like to share with you. You'll be the first to know. Thank you so much. Take care, and I'll see you soon.